Hi, everyone. Thank you so much, Sierra, and welcome, everyone. This is the 2022 New Laws to Know webinar with Colorado Coalition Against Sexual Assault. My name is Elizabeth Newman. I am the Public Policy Director at CCASA. So my job is to amplify the collective voice of our membership throughout the state and develop and advocate for legislative concepts that will improve the response to and prevention of sexual violence. I staff and run our CCASA Policy Committee and provide consultation, training, and technical assistance to our members and partners on legislative changes and the impact of laws and policies in Colorado. So for today's presentation, we're going to start with some of the state legislative changes that have been passed in the last year in our legislative session, and then I'll do a couple of federal policy updates that might be helpful for you to know. So starting with our state policy, here we have Governor signing our funding bill with Rep. Duran at the podium and Senator Winter in purple behind the governor. That was our main priority for 2022. The state, like all states across the country, received a large sum of money from the federal government to respond to the COVID pandemic and to address some of the economic impacts. There were nearly about $2.5 billion that the lawmakers had allocated for 2022. And there are 36 or so bills that passed to fund things like the debt with unemployment insurance, initiatives and investments in housing, a lot for behavioral health and workforce development, among other topics. Those were the primary focus areas. Specifically for our work, we focused on a few pots of money. This is actually the all the money Colorado received. In 2021, we were able to secure $15 million for victim services funding. And then we also worked to kind of pull some more funding from that pot this year, as well as the other two purple boxes, which are the behavioral health cash fund and the affordable housing fund. And I want to just give credit to Violence Free for putting together this really helpful chart to kind of visualize where that money went, all of those dollars. So in 2021, we had $15 million for victim services. This year, we wanted to make sure we addressed the increased need for victim services, and especially our community-based victim services programs in the state, who are really, we're seeing a lot of increased need, more stress and strain on staffing, and also a looming deficit from the federal investment from the VOCA funds. And so we convinced with a lot of effort and help from all of you, the state legislature to provide $38 million to backfill what would have been a gap about that big in victim services funding through the Department of Criminal Justice. Additionally, the behavioral health pot of money allocated $6 million to the domestic violence program in DHS, specifically to support community-based domestic violence and sexual assault services. $3 million for state and local bail, again, a backfill there for some decreased funding that had been part of the COVID impact, and then $1 million for the community crime victim services in the Department of Public Health, which is really targeted at historically underserved populations. So this huge amount of funding, $48 million in total, is really to make sure that programs stay open, that they're able to continue providing services, although it's a large amount of money, because it's really addressing a gap that was created through changes at the federal level. It's mostly maintaining things as they are. We are really excited, though, that this year there was funding from the general fund, which is, just the overall pot of money that the state legislature has to allocate to things. And that's the first time they've dedicated funding to victim services. A couple more notes on this bill. So Senate Bill 183 also had some efforts to address equity in victim services. So there was language that addressed and acknowledged the disproportionate impact of violence on marginalized communities, as well as some demographic reporting that will be required under these grants. So specifically looking at, the amount of funding received, the number and types of crimes for the victims who are served, and as well as the organizations, some demographic information from the organizations that are receiving funding. There were also some changes to the DVP statute. So that's specifically the statute that creates the fund from the domestic violence program at the state level. It is not addressing criminal or civil code. It's specifically around this statewide program, and some of it was a little outdated. So for one, sexual assault was not included in there originally, so that is now added in that DVP can fund sexual assault programs. The old definition was around domestic abuse and included really a focus on people who were living in the same residence. And now it's been updated to talk about behavior or threats around abuse to control another person who they were in, were in a relationship with, as well as the first definition of teen dating violence in Colorado statute, specifically, again, talking about that type of behavior with a person when one or both people are under the age of 18, and including the use of sexual violence against a person in that relationship. The language around the DVP statute also added in the ability to fund tribal coalitions. We currently do not have any tribal coalitions in Colorado, but it makes sure that should they be formed, they are allowed to access this funding. And it also included language around culturally responsive services. So providers from diverse backgrounds and also serving underserved populations. Before we move on, I just wanted to take a moment to pause and give an opportunity for any questions. As I do that, I'll just mention a thing about the funding that came through. The funding, the large $38 million that went to the Division of Criminal Justice is to fill those applications that have already been submitted to the VOCA grants. So that just kind of makes sure that they can fund most of or some of the requests that have come in through that grant program. The funding to DVP for the $6 million, that is forthcoming. We hope that they'll have those RFPs out soon, but that's a process that they're still figuring out. So those funds will be forthcoming. They do have to be allocated by the state by 2024 and used by the programs that they're funding by end of 2026, because these are the ARPA funds. They do have more specific timelines. However, they have a little bit more flexibility in what they can be funding. So just a note on those grant programs. Are there any questions though on this bill overall before we move on?
Elizabeth Sierra here. I'm keeping an eye on the chat, not seeing anything yet, but if there is, I will hop in.
Perfect. Thank you so much. And as we go, feel free to put your questions in the chat. And, if there are questions you have later on, there'll be another opportunity for that.
Hey, Elizabeth, there is something that just came in. Can you give an overview of what the teen dating violence definition changes are?
Yes. So it actually creates a new definition. So teen dating violence wasn't separately defined in Colorado statute in any place. This is, again, specifically for the DVP statute. So just to be clear, it doesn't apply to criminal or civil code changes. And it specifically says that teen dating violence means a pattern of behavior in which a person uses or threatens to use physical, sexual, mental, or emotional abuse to control another person who is in a dating relationship with the person, and one or both persons are under the age of 18. It can also mean behavior by which a person uses or threatens to use sexual violence against another person who is in a dating relationship with the person and one or both persons are under the age of 18. So there is language there that was developed specifically to just kind of get it in there. And, hopefully we'll lead a pathway. We'll make sure that there is funding allocated for those services in the future.
Thank you, Elizabeth. We did have another question come in. Who are you seeing as the largest underserved cultural population?
I can speak to specifically the statute. I don't have, and others can feel free to add in who they think are some of the underserved cultural populations. What the statute says is, excuse me, so culturally responsive services by providers from diverse cultural backgrounds, and they're providing these services to American Indians, Alaska Natives, Eskimos, and Aleuts, Asian Americans, Native Hawaiians, and other Pacific Islanders, Black or African American, Hispanic or Latinx, or any underserved population in order to assist victims of domestic violence and sexual assault. So those are, that's the culturally specific programming language. Is really around that racial and ethnic diversity, but also has space for any underserved population. I hope that helps. Okay, great. So moving on, another top priority from CCASA was to address gaps and barriers to treatment for survivors. This was specifically around a change in the guidance from the Centers for Disease Control and Prevention that encouraged the use of 7-day packs of antibiotics to prevent sexually transmitted infections. And this was spurred by antibiotic resistant strains of some STIs. The challenge was that hospitals had a statutory limit to only provide 3 days worth of drugs to a patient. And so if someone during the course of a forensic exam, a sexual assault forensic exam, needed to take STI prophylaxis drugs, they were, only either had the option of getting a one-time dose at the hospital or getting a prescription for the full 7 days, which, can be filled by a hospital pharmacy, but sometimes might not be open or available. And then just puts an additional burden on the patient, not only to procure the medications that are needed, but also pay out of pocket and submit reimbursement, things like that. And so, just a shout out to the SANES in Colorado who, brought this to our attention and asked for help. It was a pretty strongly supported bill to allow that specifically for sexual assault patients in a hospital setting, that hospitals could dispense 7 days or up to 28 days worth, between 7 and 28 days worth of drugs for STI prophylaxis. So that's to prevent infection. What we know this means then is that when someone is at a hospital getting a forensic exam or care in the aftermath of a sexual assault, that they can receive not only the full 7-day pack for STI prophylaxis, but also the 28-day supply of HIV post-exposure prophylaxis, so HIV PEP. This law is in effect now. It is up to each hospital and program for how they are responding for the implementation. But the idea is that it's going to remove costs. Now hospitals can handle the billing between either the survivor's insurance, law enforcement, victims comp, or the SAFE program to cover the cost of those medications, as well as to save them time and the really just the hassle of going to get those drugs to treat and prevent infection. Any questions on this one? We can come back if there are. Okay, so the next bill I wanted to mention is to ensure that everyone knows that abortion access is legal in Colorado, and that was further enshrined in this Reproductive Health Equity Act. So in anticipation of the Supreme Court ruling on abortion access, there was an effort in Colorado, which CCASA supported, to make sure that not only do we not have those restrictions, but that we further have the rights in our state statute. So all people in Colorado have the right to refuse or use contraception, to continue or terminate a pregnancy. In Colorado, we do still have parental notification for youth under 18, and there's the process to avoid that if there are issues with parental notification. It's not approval, it's just to let them know. But other than that, there are not restrictions on time in pregnancy, how far along you are, any of those waiting periods, any of those things. So, and we have this further enshrined as a right. It also set forth that there are not individual rights for fertilized eggs, embryos, or fetuses, that they, the rights of the person who is carrying the pregnancy is, the individual rights rather than the, potential baby. So that's where Colorado has really taken a strong stance to make sure that people know that they can get abortion services in Colorado. We also, know that our neighbors around us are having some restrictions in place. And so, really Colorado, I know that the abortion providers here have said they're seeing an influx of patients from out of state. So just for you all to be aware that because we do have this access really protected here, you might see folks from other jurisdictions, other states. Okay. As we move on, another bill that came out this year was around updating the definition of sexual assault in the criminal code. Is there a question?
There is a question. Does the bill address who pays for these services, particularly for pregnant teens?
You're talking about the Reproductive Health Equity Act, I think, which is not related to funding. There are some, insurance can cover those services here. If someone has been a victim of rape or incest, the state, and they're on Medicaid, the state Medicaid program will cover the cost of abortion. It will not cover it without that. So they do have to have that that exception. Otherwise, state funds cannot be used. And then there are some abortion funds available in Colorado that serve particular populations, but there isn't, it's not included in the bill. So another bill, as I was mentioning, updated the sexual assault criminal code. So this is House Bill 1169. Specifically, previously, the sexual assault was defined as sexual intrusion or penetration when the actor causes submission of the victim by sufficient means to cause submission against the victim's will. And this was confusing. It made it more difficult for charging cases. It made it more difficult for juries to make findings because there was a lot of questions and discussion around what does it mean to be using means sufficient to cause submission against the victim's will. So that is out the window. Going forward, starting in July, this last July, they updated the language. So now it is when the actor causes sexual intrusion or penetration, knowing the victim does not consent. And so it's very clear on that. The intention is to align the language both with kind of our cultural understanding and our societal understanding and language around consent, as well as aligned with unlawful sexual contact, which has that same language around knowing the victim does not consent. So it, as I mentioned, it is in effect as of July 1st. So that is for all incidents that occur on or after July 1st. So any cases before that would still be using the old definition. Questions on this one?
There is a question. How does the bill address ignorance defenses?
Right, so that the perpetrator didn't know the victim didn't consent is, I think, what you're asking, which is always a problem, and always going to be. So in Colorado, and I think in pretty much every state, criminal acts require that the person knew that they were committing a crime. There are a few where it doesn't matter, but for the most part, they do require that someone had that intention to commit a crime. Excuse me. So that is already a part of kind of the overall criminal language in the state. Of course, the defense is always, that's a common defense, but prosecutors as well are now knowing that they have a little bit more ability to say, what was required is that they knew the victim didn't consent, not what was required was that they knew the victim didn't consent and they used means sufficient to cause submission. So it's like, it's better. Of course, it's not perfect, but there are always, ways that the prosecutors will, try to establish that.
Thank you, Elizabeth. We do have another question. Does that mean the victim needs to be verbal, or is it based on nonverbal body language as well?
Yeah, so in Colorado, we have consent defined in the statute, and it is, I think it's act or attitude. So it is nonverbal as well as verbal. So those can both be a part of it. And again, going back to sort of how this language is better, is that it doesn't require that like causing submission, right? Like, because I think we understand that there are different ideas of how someone might, respond when they're being assaulted, and that it might not always look the same. And so, having more of a broader interpretation of, what it looks like for the victim to not consent is allowed under this statute. Did I get to that question? Okay, great. So one big bill that came through this year that CCASA was involved with was updates to the Victim Rights Act. So Senate Bill 49 made a few changes. Primarily, this is sort of a bill that clarifies and updates victim rights. It's not a huge change, but it does a couple important things for people to know about. One is that it adds invasion of privacy as a crime under VRA. So this is important because invasion of privacy for sexual gratification was already included, but sexual gratification can sometimes be hard to prove. And so someone may only be charged with just invasion of privacy. There were two other bills added around, or two other crimes added around arson and burglary. But I'm really just going to focus on the pieces that are, I think, most relevant for you all. I do encourage, if you don't know a lot about the Victim Rights Act, or you just want to kind of get a deeper dive on this, to tune into the Rocky Mountain Victim Law Center's webinars and trainings on VRA. You can even ask them to come and speak to your organization or a group of folks about it. There's a lot to the Victim Rights Act, so just heads up that this is specifically kind of what we felt like was most relevant for our members to know about, but there's obviously a lot more to it. So adds criminal invasion of privacy. They are now entitled to victim rights. Clarifies that the right to appear for at critical stages in the process can be in person, by phone, or virtually. So previously it said in person or telephonically. It just knows that, things, it's just to update and reflect that, there's new technology, right? People can join through virtual avenues, and just kind of making sure that's in there. I will say that not all judicial districts and courts have that available, right? But it's just to say, if they do, that can be part of how someone appears. Another thing that's important is that subpoenas for privileged records has a stronger process now to protect victim privacy, and more safeguards in place. So specifically, now to subpoena privileged records, which could be, medical, mental health records, other personal information. They do have to be privileged, not just personal, but privileged, that they must file a subpoena that includes a certificate that it's in good faith and for a lawful basis, that there's a good reason to do this, a notice that advises the person who's being subpoenaed for those privileged records not to release those records without a court order, a motion that explains the lawful basis and the waiver of privilege. And so the court must make a finding that these records should be released, can and should be released before the person who has the records provides them. And after the court order, the records have to be produced within 7 days. So it's not like tomorrow and you're, staying at the office all night trying to compile all the records for a particular client that you've been subpoenaed for. This says, wait until the court orders them to be released, and then you have 7 days to do that. So that's really important to make sure there's not, just these fishing expeditions that just kind of look for everything and see if there's something in there. The public defenders or the defense does get informed of, the fact that you've been notified and things like that. But that's already basically part of it. The bill also established that translation or interpretation must be provided by the courts during the critical stages of the case. And the courts are responsible for paying for that translation and interpretation. This must be arranged with DAs ahead of time. So if you are working with a survivor who needs translation or interpretation, make sure that the DA's office knows ahead of time to make sure that they can make those arrangements. But that should be on the responsibility of the DAs to arrange that and the courts to pay for it. Also, victims were already entitled to receive a free copy of the initial incident report, but it was just inconsistent across jurisdictions on what that actually contained. And we know that it's oftentimes very useful for insurance, civil cases, ending your lease, all those things, to have that information on an initial incident report. So this change clarifies that all initial incident reports must include the names of the victim and offender, the date of the incident, any charges that were brought, a summary of the incident. Just making sure that everyone has the information they need in order to, file those claims or, get other protections involved. They can be redacted if there are family members or others that are not specifically the victim. So if both Sierra and I were a victim of a crime and I request an initial incident report, Sierra's name would be redacted, and when she requests, my name would be redacted, but otherwise we'd be getting the same information. Okay, any questions before we move on?
We do have a question, Elizabeth, just going back to HB 22-1279. Just to be clear, the pregnant woman has a right to abortion, but the fetus and father do not. Is that correct?
Correct. This does not allocate any rights to the other person. It's specifically the person with the uterus, the person who is pregnant, who has those rights. I will say the right to refuse or use contraception is broad, and it's not specific to either party. It's not only the person who can get pregnant who has that right. But, again, going back to consent issues, if someone is, having sex with someone who refuses contraception, they need to be informed. They should be informed about that and able to make their own decision. So that's not to say that the right to use or refuse contraception is limited only to the person who can get pregnant. It is applied to all people in Colorado, but the decision to terminate a pregnancy is specifically the right of the person who is pregnant. Does that answer? Okay.
Thank you, Elizabeth. There is another question. So just going back, so free copy of the initial incident report. Does the case have to be closed before they can request this? Do they request it from law enforcement or the DA's office?
Great questions. So the case does not have to be closed. It is just after an incident is filed. And then you would request it from law enforcement, from the local, because they would be the ones who have the incident report. Any other questions before we move on? This is great to get all the clarity now, but you can also feel free to bring things up as we go. If you are like, well, wait, I'm not sure I caught that. Feel free to jump in anytime. Okay. So moving on, another important bill, and this is again around sort of this criminal legal side of things, is safe reporting for sex workers. So House Bill 1288 creates a greater protections for sex workers who often experience high rates of violence and other crimes. So this law establishes immunity, which means that they cannot be prosecuted for prostitution-related charges. They also should not be arrested, but there's a little bit less, I think, actual protection there. But at least the prosecution, they can't bring forward any charges because they would just be tossed out. So prostitution related charges are not only acts of prostitution, also displays of prostitution. So that's kind of an old, a little bit outdated law maybe, but it was basically someone's looking like they're a prostitute or acting like that. And so the change here is really to say that it is more important to allow people to seek police or medical assistance after being a victim to or serving as a witness of a crime, of a violent crime, than to prosecute them for trafficking. So it's just kind of prioritizing their prioritizing their safety over the criminalization of sex work. Specifically, this is related to reporting, serving as a witness. Also, minor victims of sex trafficking are in there, although that was already part of it. It's just kind of making it consistent. And the hope is that people will, feel more comfortable cooperating with police investigations, making reports, or seeking, going to the hospital if they need care, not worried that there's going to be that the police are going to come arrest them. A couple notes is that this does only apply to certain types of crimes. So they do have to be violent crimes, things like sexual assault, unlawful sexual contact, enticement, internet luring of a child, human trafficking of a minor, menacing, extortion, stalking, murder, assault, kidnapping. All those types of crimes are what is covered under this bill. And it only applies to that process of making a report or serving as a witness or getting assistance. So if the person was engaged in sex work at the time of the crime, the information that they provide to police about that would not be then used against them to arrest them for prostitution. But someone couldn't just, be going about their normal day. And later on, try to get that immunity. So it's specifically during that process of reporting or serving as a witness. Questions on this one? It is in effect now. And it does apply, across the state. So, we know that not all kind of police officers get the same information at the same time. So we do expect that there might be some need to do more education with the population that's directly affected, as well as making sure law enforcement is aware of this. They do get their training typically, I think, in October or something. So, but they're not supposed to be arresting them, and they're not supposed to be charging them for prostitution charges only. It doesn't cover things like drugs. It doesn't cover, unlicensed massage, any other charges. That is still, something they could be arrested and charged with, but it's specifically that prostitution charges.
Just wanted to chime in here, Elizabeth. You may have just answered it, but wanted to ask anyway. What if they have outstanding warrants? Are they protected from that as well?
No, it's not going to address outstanding warrants. And of course, it's always up to the DA. So on some of these things. So if someone was arrested for, you know, they had a previous arrest for prostitution, and let's say they didn't attend their court hearing, and so they had a warrant, you know, someone could make a case, right, that should not be, because of the new laws, should not be part of it. But these are primarily petty offenses now. They're not you know, like felonies or anything. So for the prostitution piece, so they're a little bit lower priority as it is. And now, you know, there's just that assurance that they would not be arrested or charged for those prostitution charges. So it doesn't cover past things. It doesn't cover all outside crimes outside of that initial time of the witness being a witness or a victim to a crime, violent crime. Any other questions?
So that's inclusive of domestic violence and intimate partner violence. Are they protected from that?
So it doesn't, the list of violent crimes doesn't include reference to like a DV enhancer statute. It's specifically the acts of things. So, you know, stalking and assault would be there. But if there were other forms of domestic violence that aren't covered by some of these crimes, then it's not quite 100% clear that those would be on there, right? Does that make sense?
We did just have another question. How about underage use of drugs or alcohol, for example, by victims under 21 years of age?
Yeah, we were trying to get other, you know, illegal activities someone might have been involved in, especially someone who, you know, might be engaged in sex work, you know, might be also engaged in other illegal activity. The DAs were really resistant to that. And ultimately, in order to get a bill that could pass, it was limited to just those prostitution charges. So just specifically those 3 charges around the act of prostitution, soliciting, and making a display. I think there's a lot of room for this to be improved and expanded to make sure it's real, because we know that not everyone is going to have the perfect situation, and that people who are engaged in sex work can really be vulnerable to some other behavior that might be, you know, criminalized, and whether or not they're doing so willingly or as part of, you know, maintaining their safety. Yeah, it's not as protective as we had hoped, but it is a step in the right direction. And we hope that it could be built on in the future. Any other questions on this one? I know it's kind of a shift from sort of typical laws changed here. So it's part of a bigger movement overall across the country. A number of states have adopted similar laws to provide that immunity and that protection, to make sure that sex workers can be safe, knowing that they are often vulnerable because of that, you know, concern or fear of reporting due to the other activity they might be engaged in. Okay. One other criminal, I think this is one of the last, or I think we have 2 more criminal legal system laws to talk about. Senate Bill 24 addresses intimidating a witness or victim. What it does is expands protection under that statute. So, you know, you have already victims directly as, you know, and witnesses directly as protected under intimidation statutes, but this expands it to include those who the defendant believes may have relevant information, whether or not they do. But if they're being targeted by intimidation, acts of violence, threats, in order to keep them from, you know, sharing that information with police that would be helpful for an investigation, that they are protected. So it's not only directly a witness or a victim who's already been identified. Also, it includes those who may influence the victim. So this could be things like the victim's parents, someone who's outside of that direct victim witness relationship to the defendant, but the defendant believes might be able to influence the victim, prevent them from participating in the criminal legal system. It also, and this is important, understands that intimidation might occur prior to charges being filed. So, when there's been an arrest made or a report made, it really is starting the clock then, as soon as there's sort of a opportunity for intimidation to occur. And then this became effective on July 1st also. So just to note, it does apply to specifically those acts of intimidation starting from July 1st and on. Questions here?
Nothing yet, Elizabeth.
Okay. We can come back if you think of something. One other thing to note is that there were some changes to restitution. So restitution means like that you had a monetary loss suffered by the victim, and that was caused by the defendant's conduct. So it has to be something that can be calculated, like out-of-pocket expenses, interest, loss of use of money, anticipated future expenses. It cannot be, oops, I'm sorry. I don't know, got really far ahead here. There we go. It cannot be things like loss of future earnings or physical or mental pain and suffering. Those are separate, but restitution is specifically holding the offender responsible for those costs that the victim suffered. The problem is that it's often really difficult for victims to navigate, and some of the things that they might actually suffer as a cost were not previously explicitly identified under restitution. So two things that this bill does. One, it creates a new Office of Restitution Services, which is there to really help victims who are owed restitution and collaborate with victim advocacy programs to make sure that they know how to support victims in pursuing restitution. So it's really just there to kind of be a point for victims to seek information and support and help with this. The other piece is that it sets forth some explicit allowable expenses. And these are not limited to only these items, but it just says that this is going to include long-term or ongoing medical expenses, any insurance deductibles, again, related to the offender's conduct, replacement costs for damaged or destroyed property, and then expenses related to participating in court. So for you to go, if you have to travel more than 100 miles one way, there's costs for the travel expenses or where that might be. And then also if you have to have childcare, or you lose out on a work day, so you have lost wages for participating in court, those costs can be covered under restitution.
Elizabeth?
Yes.
Where is the office housed?
Great question. I am not 100% sure on that right now. And I can look that up as it relates to, I thought it was going to be within the courts, but I'm not sure. It might actually be within, I'm not going to speculate. I'm going to find out for you. Thank you for that question. Okay.
We also had a question, does appropriate clothing qualify as well? And then we had someone respond, the office will be in the judicial department.
Oh, great. Yes. And I also have that in my notes now. I'm looking at that it'll be in the judicial department. So because that's also where they calculate and collect and distribute all restitution. So thank you very much for that in the chat. And then as it relates to court, no, it doesn't include clothing. That was not listed as one of the allowable expenses. Okay. going to move on. So one of the other bills that CICASA worked with our community partners on was Senate Bill 150, which addressed the crisis of missing and murdered Indigenous relatives in Colorado. So pretty much this has been really started in Canada, but there's been a lot of attention kind of nationally and in North America around high rates of violence against Indigenous people, and particularly a lack of attention and response, or insufficient attention and response to these cases. This was really exemplified by the Gabby Petito case, which created quite a media attention, a lot of awareness for a missing persons case that just really is not matched for Indigenous people. And we know, Colorado law enforcement got involved in that case, whereas there are other cases involving Indigenous people where the families just feel like they're not getting any progress. So we joined some members of the Indigenous community to help advocate for this bill, which creates an Office of Liaison for MMIR. So that's going to be within the Department of Public Safety. And that is supposed to be there to kind of provide that coordination to support the interagency work, the investigations, training, awareness, things like that, to help really support an improved response and better communication. The bill also requires that there is an alert system set up. So now if there is an Indigenous person who goes missing and the circumstances are appropriate for an alert, then there is a specific Indigenous persons alert, missing Indigenous persons alert, that can go out statewide to not like an Amber Alert, but there are at-risk person alerts that go to the media, that go to all the law enforcement agencies. So that's the type of alert system it is. There's more training for law enforcement, as well as some new data reports that are going to be required for the Department of Public Safety to issue, kind of the number of cases, what's the status, any kind of trends being identified, as well as making sure that if a member of a federally an enrolled member of a federally recognized tribe goes missing, that the tribe themselves, that their law enforcement is notified to make sure that their and leadership is notified to make sure that they kind of are aware of that missing persons case. So this is just getting off the ground, but we hope that it will make a better response overall and increase sort of the awareness both internally within law enforcement, as well as broadly within the public about these cases. Also wanted to just mention there have been a few changes around behavioral health. So CICASA was involved in efforts to address the behavioral health needs for survivors. This has been a new direction that Colorado is taking, is really investing in trying to resolve some of the ongoing and longstanding issues around behavioral health care in Colorado. So one of those things was creating a behavioral health administration, a separate agency to work on coordinating and putting together strategies and supports for behavioral health services in Colorado, including an advisory council, which CICASA strongly and successfully advocated for the inclusion of expertise in trauma, crime victimization, and adverse childhood experiences on. Also important to note for anyone who is a mental health professional, next year when you go to renew your license, the fee will be reduced. It is not exactly prescribed by how much, but it's up to all the boards that oversee the licensing for psychologists and social workers and marriage and family therapists, counselors, addiction counselors, other mental health professionals. They will be able to reduce the fees to kind of give a little break for mental health professionals. We also successfully advocated for trauma-informed training and trauma recovery treatment in 2 of the new behavioral health grant programs that were established with the federal COVID recovery funds. as well as we supported a bill to add the Colorado Crisis Services phone number, website, and text talk number, and the Safe to Tell number on public school student IDs. And that should be starting this year. So if you have a student in your life and they're in public K through 12, and they have a student ID, it should have that number on it. If they don't have a student ID, they are supposed to have that information publicized in an easily accessible place as well. But for now, we just wanted to make sure people knew that we are trying to support greater access to behavioral health services for survivors. And we hope that some of these changes will trickle down to the programs who do provide a lot of those services oftentimes. And then another kind of just good to know what's on the horizon. There were quite a few bills requiring task forces and studies on relevant topics, and these typically lead to legislation down the line. So this year, the legislature they passed to establish a study on Title IX in K through 12 schools, and they will be, I think, responding to that study, which should come out at the beginning of 2023 to really move forward some legislative changes on this topic. There also will be a task force to look at changes to mandatory reporting. There was a bill to address some of those gaps in underreporting this year. It ended up being, quite a complicated issue with a lot of different perspectives from different stakeholders, including CICASA and Violence Free Colorado, who really raised up issues concerning confidential victim advocates. And so that instead will all be resolved and responded to by a task force, which will be working in the next 2 years, I believe, to issue a report, which will probably include some legislative recommendations on mandatory reporting. Additionally, there is a task force to set up a pilot program that will screen victims of violent crime for brain injuries. This is in response to a program to screen people who are incarcerated for brain injuries, understanding that that might be an issue that they are not getting treatment for. In response, some victim advocates, really wanted to highlight the fact that many victims of violent crime do sustain brain injuries and often may not be adequately screened for them. So this is, again, establishing a task force that will establish a pilot program. So it's not going to be a widespread change right now, but it is, progress in that direction. And the last task force that I wanted to mention is that there will be one set up to assess service gaps related to raising the minimum age of prosecution from 10 to 13. So currently a 10-year-old who commits a crime can be prosecuted, and this raises that to the age of 13 with an understanding that children should still be getting, support and treatment, or, have some kind of response. It's not saying, they can just commit crimes without any kind of response, but it's saying that arrest and prosecution is the piece that is unnecessary trauma for them. We have been involved in this conversation specifically around children who display problematic sexual behaviors, and so CICASA will be involved in this task force to make sure that those youth receive treatment, and also that their victims get the rights, resources, and services that are needed to maintain their health, safety, and well-being and healing in the aftermath of an assault. So that's kind of just a preview of what types of legislation will probably be coming forth in the next few years based on the work of these groups, and primarily, besides the Title IX one, which is just a study done by an outside party, the other three are going to be task forces. So those will typically be public meetings. There's an opportunity for stakeholder engagement. So if you have interest in some of these issues, there is an opportunity to have your voice heard. Before we move on to some of the quick federal policy updates, are there any questions on any of the bills covered today or any other state legislation?
Not seeing anything currently, but I will check back in if someone wants to share, has a question, comments, feedback in the chat.
Great. Thank you all so much for your active participation. I think answering questions from you as you go really helps you to, make sure you understand these changes. And it's important, for us to make sure we provide that for you all, because we can change the laws all we want, but if people on the ground don't know about them, can't make sure that, survivors are aware of their rights, or, law enforcement is following, the changes in the law, then they're not really real. So it gets down to that granular level. Okay, there were a few things that happened in Congress. Normally, I don't think that Congress doesn't seem to do as much on these issues, but there actually were some progress in the last year that we wanted to share. So VAWA was reauthorized. That's a big headline of the year. So there was a long process to get to a bipartisan Violence Against Women Act reauthorization, because it had expired previously. Ultimately, ended up being passed in the omnibus package. So that was like a whole bunch of things. It's like a 900-page bill, but part of that was reauthorizing VAWA. And within that, there are a couple of things to note. One is primarily VAWA establishes grant programs. So that's the primary thing that it does. And so it reauthorized existing grant programs through 2027, and it established some new ones that are targeting some areas where there is a real need for a stronger investment. So in particular, we see increases for rape prevention education and sexual assault services programs. Those funds, so there should be more money for sexual assault services. It expands the grant programs to enhance culturally specific victim services programs for LGBTQ populations, and supportive services for Indigenous victims. There are grants for technology to better detect bruising across skin tones, and other culturally specific programs. It also expanded jurisdiction of tribal authorities to non-native offenders. This was a long-standing issue, and it really increased the ability for non-natives who perpetrate violence on tribal lands to then be able to be held accountable for those acts of violence. It increases tribal law enforcement access to federal databases. So there's a lot there for tribal protections. Another really interesting thing is that it supports greater protections for intimate image abuse. So it established a federal civil cause of action, so civil meaning like a lawsuit, for individuals when they have intimate visual images disclosed without their consent. So it allows them to recover damages and legal fees. It also creates a new National Resource Center on cyber crimes against individuals, really kind of recognizing that the internet and social media and things have allowed a new way for people to harm others. And then it also supports state, local, and tribal government efforts to prevent and prosecute cyber crimes, including cyber stalking and non-consensual distribution of intimate images, or sometimes called revenge porn. So lots of new things in there around that intimate image protection piece. Another piece for some of our campus groups to know about is that overall, VAWA establishes some restorative practice pilots, but some specific to campuses, also funding prevention education, and requiring a training for those who work directly with students. So whether they're like health employees, services employees at a school, or professors or things like that, that they be trained in recognizing and responding to gender-based violence on campus, as well as requiring the Department of Education to develop and implement a survey tool to track sexual violence among college students. So any college or university, higher education institution that receives federal funding will be, first, the Department of Education has to develop it, but they will be deploying a survey tool, and those results have to be published they have to be de-identified, but published on their website or a college scorecard or wherever they have that kind of information shared. And also for the Government Accountability Office to look at the relationship between sexual violence and survivors' ability to pay student loans and their, the economic impact for them. And lastly, there'll be a interagency task force within the Department of Ed, or with the Department of Ed, Health and Human Services, and the Attorney General, their office, to develop a plan to address sexual violence in education. So a lot of investment in higher ed and sex assault on campus. Any questions on VAWA before we move on? Right now, we are in a place of waiting for Congress to actually appropriate the money that they authorized. So the actual amounts of funding coming through for these programs is still not defined. There's, what was passed in VAWA, what the president's budget looks like, and then what Congress actually passes. That still needs to be worked out. But as of this time, we are still seeing expecting increases to sexual assault services, and as well as these other pieces, the grant programs, how much they actually allocate is different sometimes, but the programs have been created under the new VAWA reauthorization. Another bill to be aware of addresses the issue of, excuse me, forced arbitration. So when Me Too happened, we learned that a lot of people who are filing oftentimes workplace harassment or sexual assault complaints are forced into this arbitration as their means of getting justice. So arbitration is, a sort of supposed to be a neutral sort of mediator type arbitrator, is kind of like a judge, kind of like a mediator, who works with both parties to find some kind of resolution. And so it's not public. It doesn't have, a jury or anything. It's just the arbitrator. The reason that this created such an unbalanced response for cases like this is because if you're a company and you're forcing, issues, employment issues and things through arbitration, the people who are on sort of the employer side of things, they're going to know the arbitrator, they're going to know the process, they're going to know how, kind of how to get the most of it for them. Whereas the victim is not going to be familiar with the process, doesn't have, they might have some representation, but it's not like a lawyer in front of a judge. So they don't really have the same, it's not an even playing field. So this bill moves forward specifically around sexual harassment and sexual assault. There were efforts to try to broaden that, but it was limited here for bipartisan support to ban forced arbitration in all employment and consumer contracts. So that's like if you're signing on your app for Lyft that you're going to accept arbitration for any disputes. It does not apply to sexual assault or sexual harassment. It was, when it was passed, which was earlier this spring, it went into effect immediately and it applied retroactively. So if you, 3 years ago when you set up your Uber account, agreed to that, and you had even 2 years ago had an assault, it still would not apply to it. You would not have to go through arbitration. This ban on them would be retroactive unless you had a case pending. So if you were already in the process, you have to continue through that process. But otherwise, it applies to consumers, terms of agreements for using a product, and employment contracts. Any questions on this one? Okay. The last bill I wanted to talk about is related to sexual assault in the military. This was passed in the end of last year, and it's in the National Defense Reauthorization Act. Congress moved forward some reforms that will kind of protect more victims and provide a more fair process for them. And so this is specifically establishing a special trial counsel to prosecute these crimes. So it's attorneys who are military attorneys, but they are independent from from the chain of command and from the other, any other types of process, like, making sure that they are separate from the reporting and that process there. So it specifically, has this, has attorneys and the judge also are outside of that chain of command from the survivor and the person who's been accused. So that's a piece that is, helpful for making sure that there is a fair trial. It also includes sexual harassment as a general punitive article under the Uniform Code of Military Justice. So this is making sure that these types of acts are prohibited and can be punished, and requiring some independent investigations for sexual harassment as well. So it doesn't go necessarily far enough for many folks, but it is a step in the right direction towards creating that pathway that's a little bit more of a fair trial and process for a sexual assault in the military. Any questions on this one?
Yeah, we have a couple comments in the chat. Does it prevent commanders from changing verdicts?
Yes, it does prevent commanders from changing verdicts. So by having that, it's by having that special trial counsel, they will be binding, and a commander or any other authority cannot override them.
And then we just had a comment that said many of these changes are still in the implementation study phase.
Thank you for that, Ken. Yes, it's important to recognize that when a law passes, it's not like, some things, right, when they pass, they're implemented immediately, particularly, especially with the military, but all government agencies, change takes time, and they usually have a rollout, and, some studying to do on these things. So thank you for clarifying that. Much of this is not real yet for victims to have that process necessarily. And someone who's specific in military policies, I'd love to hear if you know what pieces are in place at this time.
I'll just share that Ken shared the head of this new trial counsel office will report directly to the secretary of their branch of service.
Yes, that's right. So each service will have their own special trial counsel. Great. Okay. Well, that was all the bills. Those were all the bills we wanted to cover today. But if you have any questions, happy to answer them now. You can also feel free to reach out to me. Email is the easiest way to contact me. And I'm happy to provide more information. CICASA is working on some explainers for some of these bills to make sure that you can share them, our members can share them with their teams to, really help educate your colleagues, those who might be working directly with victims, those who might be working within the law enforcement reporting process and other places, to know what these new changes really mean for your work. So those will be coming shortly, and we'll send that out for everyone who is a member to know when those are available to access. Before we wrap up, any final questions?
We did have a question from Jennifer, off topic. Will you please tell me the bill regarding DV in Colorado?
Can you expand on what you're looking for there? A bill regarding DV.
Also just wanted to share, Ken is open to collaboration, which is very exciting.
We love that. Thank you very much. Happy to work with any of you all if you have ideas for policy. We always are happy to explore whether that could be a legislative change that CICASA can support, and always willing to collaborate with members and programs and others across the state to make sure that you all can do your jobs. That's our goal, is to make sure that we kind of can remove barriers, things that are getting in the way of you helping survivors get the healing and accountability and justice that they're looking for. So please feel free to be in contact with us for any of those ideas or questions or comments. And then was there greater?
Yes.
Yes.
It's in regards to DV victims reporting their crime.
I just say I'm not sure what that bill might be. So maybe we can offline if you want to email me, and I'm happy to talk more about that.
We did have another question. Will you have any policy working groups this fall?
So CICASA has a policy committee for members who are engaged in the policy arena. So that we meet monthly, and our policy committee, helps to kind of inform our position, helps to educate legislators. If you're not already, please be on our email list, because we will send out action alerts in the legislative session, which runs from January until May, having you contact your legislators or members of specific committees when a bill that is important for CICASA comes before them, and to let them know what that would mean for your work with survivors, or why you care about that issue. And of course, we are always, happy to work with groups and others who might want to, kind of share out some of this information. And, we've had presentations to SART teams across the state. Obviously, this webinar will be recorded, so you can feel free to come back to it later. But if you want to be engaged in our policy work, we just love to have more participation and ideas and voices around the table.
Well, thank you all so much for being here. I did just pop in the survey about today's webinar in the chat. I will be sending a follow-up email with these presentation slides, as well as just some more information. So thank you all for being here. Thank you all for engaging with us, and we hope that you have a great rest of your day. Bye, everyone.
Thank you all.